Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut, and today what I'm going to talk about is Code of Evidence Section 8.6, which are the hearsay exceptions in which the declarant must be unavailable. So I'm going to talk about those hearsay exceptions as they relate to family law cases. I've done separate videos that explain what hearsay is in and of itself, that explains the basics of hearsay. And I've also done a video that covers the hearsay exceptions for when the declarant must be available. So if you're not understanding what hearsay is, I suggest that you first watch the video explaining hearsay. And then, if you're going over the hearsay exceptions, you should also see the video for when the declarant must be available. So basically, again, these exceptions apply when the declarant must be unavailable. So for a declarant to be deemed unavailable, he or she has to be absent from the hearing or trial, and the party trying to admit his statement has been unable to produce his attendance by process or other reasonable means. So, they might be in the hospital where they're unable to come to court, or they moved to another country, or they passed away. Those are circumstances in which the declarant is unavailable. Now, there are a whole bunch of hearsay exceptions that are covered in this section, but a lot of them are kind of antiquated. They're super rare. They don't really apply to family law cases. So I'm basically going to skip the majority of them, but I'm going to focus on, really there's one that is most applicable in family law cases, and that is former testimony. So this exception says that, again, the declarant must be unavailable, and it is testimony given as a witness at another hearing of the same or a different proceeding, provided A, the issues in the former hearing are the same or substantially similar to those in the hearing in which the testimony is being offered, and B, the party against whom the testimony is being offered had an opportunity to develop the testimony in a former hearing. So I think a good example of that is, let's say there's a divorce proceeding going on and you're having a divorce trial. And in addition to that, 6 months ago, there was a restraining order hearing. And during that restraining order hearing, there was testimony that the husband hit the wife after dinner one night, in front of the kids. So that was, a witness testified that he or she saw that, assault after dinner, and that was testified during the restraining order hearing. Fast forward 6 months, 9 months, and it's the divorce trial, and that witness is no longer available. It's they moved to China, and nobody can figure out how to serve them, can't get them to Connecticut to testify. Well, in that situation, you could get that testimony in through this hearsay exception. It's former testimony. The issues in the former hearing are the same or substantially similar to those in the hearing in which the testimony is being offered. So, you're offering in the divorce trial, you want to produce evidence that the husband hit the wife after dinner. And the party against whom the testimony is now offered had an opportunity to develop the testimony in the former hearing. So the husband at the restraining order hearing would have had an opportunity to cross-examine this witness. So that is, his ability to develop the testimony in the former hearing. So that's really the main hearsay exception under this Code of Evidence section that applies to family law cases. I mean, maybe statement against civil interest or a statement against penal interest. I'm not going to go into it in too much detail, but basically, if a witness made a statement against their own civil or penal interest in the past, then it could potentially be introduced as evidence if that witness is unavailable. So I don't know, let's say the husband had a friend who, said at a press conference or during a police investigation that, he and, the husband who's in the divorce trial, that he and the husband, they robbed a bank together or they embezzled money together. Well, that would be a potential statement against civil interest or statement against penal interest by that witness, that would potentially make the hearsay statement admissible so long as that declarant is unavailable. So those are the basics. Again, these circumstances are somewhat rare in family law cases, but you do still want to be aware of them. And, I'd suggest that you read through the whole statute or code of evidence section just to make sure you are familiar with it. So those are the basics. And as usual, if you have any other questions, feel free to reach out to our office. We would be happy to answer them.